3, 2, 1, start. On the other hand, Mr. H.S. Tolia, learned advocate appearing for opponent number 3, original plaintiff, has opposed this application and has referred the reasoning record by the trial court while rejecting the application filed under Order 7, Rule 11 of the Code. Full stop. It is submitted that the trial court has not committed any error and, therefore, this court may not exercise revisional jurisdiction. Full stop. It is also contended that the amendments made in the suit is required to be read as a whole. Full stop. It is also contended that there is no pleading in the application filed by the applicant under Order 7, Rule 11 of the Code with regard to the delay in filing the suit. Full stop. Opportunity is required to be given to the plaintiff during the course of trial to lead the evidence. Full stop. It is further submitted that when it is alleged that the sale deed is executed by foregoing the signature and when the fraud is alleged, the said aspect is required to be gone into at the time of trial. Full stop. It is further submitted that decision upon which reliance is placed by the learned advocate for the applicant would not be applicable to the fact of the present case. Full stop. Para. Mr. Tolia, learned advocate, has thereafter contended that Section 3(4) of the Act barred the relief and not the suit. Full stop. He has placed reliance upon the decision rendered by the Honorable Supreme Court in the case of Vigneswara Coop Housing Society Limited versus K. Balchandramoli and others, reported in 2005-13 SCC 506. Full stop. It is, therefore, urged that this court may not entertain the present application. Full stop. Para. Having heard learned advocate appearing for the parties and having gone through the material placed on record, it is revealed that sale deeds were executed in the years 1992 as well as 1995 respectively. Full stop. The plaintiff has filed a suit challenging the said sale deeds in the year 2008. Full stop. It is further revealed that the original plaintiff filed an application under Order 6, Rule 17 of the Code for amendment of the plaint. Full stop. If the said application is carefully seen, it is revealed that by way of an amendment, the plaintiff has specifically prayed that the defendants be directed to hand over the physical possession of the suit property to the plaintiff. Full stop. Alternatively, it was prayed that possession of the suit property be obtained from the defendants through court and thereafter, decree was passed decree be passed in favor of the plaintiff and against the defendants. Full stop. It is pertinent to note that the said applicant was not entertained by the trial court and the order of the trial court is confirmed by this court by dismissing the petition filed by the plaintiff. Full stop. Thus, fact remains that in the civil suit which is filed by the plaintiff, he has only prayed for cancellation of the sale deeds in question. full stop, para. It is further revealed from the record that after the registered of sale deeds, entries were muted in the revenue record and notice was also served to the plaintiff before the entries were certified. Full stop. Thus, it can be said that in the plaint, the plaintiff has though averred that he came to know about the sale transactions only in the year 2007 and, there, he obtained a copy and filed the suit is nothing but a clever drafting, full stop. Thus, though allegations of fraud are made, it is nothing but a clever drafting with a view to come out from the period of limitation, full stop. Para. The Honorable Supreme Court has held that where transfer is by registered document, the date of registration becomes the date of deemed knowledge, full stop. It was further held that in cases where fact could be discovered by due diligence, plaintiff would be deemed to have the necessary knowledge. Full stop. Para. Applying the law laid down by this court in the aforesaid decision on exercise of power under Order 7, Rule 11 of the CPC to the facts of the case in hand and the amendment in the plaint, we are of the opinion that both the courts below have materially erred in not rejecting the plaint in exercise of power under Order 7, Rule 11 of the CPC. Full stop. It is required to be noted that it is not in dispute that the gift deed was executed by the original plaintiff himself along with his brother. Full stop. The deed of gift was a registered gift deed. Full stop. The execution of the gift deed is not disputed by the plaintiff. Full stop. It is the case of the plaintiff that the gift deed was a showy deed of gift and therefore the same is not binding on him. Full stop. However, it is required to be noted that for approximately 22 years, neither the plaintiff nor his brother claimed at any point of time that the gift deed was showy deed of gift. Full stop. One of the executants of the gift deed, brother of the plaintiff, during his lifetime never claimed that the gift deed was a showy deed of gift. Full stop. It was the appellant, herein original defendant, who filed the suit in the year 2001 for partition and the said suit was filed against his brother to which the plaintiff was joined as defendant number 10, full stop. It appears that the summons of the suit filed by the defendant being T.S. Partition Suit number 203 of 2001 was served upon the defendant number 10 plaintiff here in the year 2001 itself, full stop. Despite the same, he instituted the present suit in the year 2003, full stop. Even from the amendments in the plaint, it appears that during these 22 years, the period from 1981 till 2001-2003, the suit property was mortgaged by the appellant, herein original defendant, and the mortgage deed was executed by the defendant. Full stop. Therefore, considering the amendments in the plaint, and the bundle of facts stated in the plaint, we are of the opinion that by clever drafting the plaintiff has tried to bring the suit within the period of limitation which, otherwise, is barred by law of limitation, full stop. Therefore, considering the decision of this court in the case of Arvindaman Supra and others, as stated above, and as the suit is clearly barred by law of limitation, the plaint is required to be rejected in exercise of powers under Order 7, Rule 11 of the CPC. Full stop.